Thank you everyone for joining our webinar today. Before we begin, just a couple of housekeeping issues. On the top right hand screen or side of your screen, attendees should have a taskbar whereby they can ask questions or raise their hand. With respect to questions at the end of the session today, if you can please type in your questions in that question section. I am facilitating this webinar today and technology sometimes escapes me. So if you can please use that question and type in the question, that would be greatly appreciated. There is a lot of information to go through today, although I said that in our last session and we managed to get through it pretty quickly. But in the event that we do run out of time for questions today, then I will keep a record of those questions and come back to you as soon as I can. The session today and last week is recorded, and so we will also take steps to share that with everyone when we can. I am also aware of a bit of a problem with my camera today and some flickering, and so as we get into our session now, I will turn my camera off so that it's not distracting for everyone. So I will do that now. Okay, so this series of webinars is on the new workplace laws. I am a lawyer, so we do need to have the usual disclaimer. The information in the session today, as well as last week, is general in its nature. It is designed to provide a very brief snapshot of the changes that came into play with the amendments to the Fair Work Act. And so if you are looking for specific advice in regards to your own circumstances, we're more than happy to provide that to you. Please feel free to reach out. This webinar series was conducted in two parts. The first part, which was conducted last week, dealt with job security, workplace conditions and compliance and enforcement. Today's webinar, part two, will talk about bargaining and workplace relations institutions. A very brief recap on part one from last week. So we talked about job security and gender equality. So amendments that were made to the Act around expert panels and some objectives to the Act. The limitation on the use of fixed term contracts in some circumstances, the prohibition on pay secrecy clauses, and amendments to the way employers are required to respond to flexible work arrangement requests and requests for extended unpaid parental leave. We also talked about workplace conditions and protections. We didn't touch on the firefighters given our audience, but we did talk about prohibiting sexual harassment in the Fair Work Act now, and some amendments to the attributes around discrimination under the Fair Work Act. We also talked about the amendments that were made to the small claims procedure, as well as the prohibition of job advertisements that breach the Fair Work Act. So today, though, we're going to be talking about the areas and the amendments that were made in relation to bargaining and workplace relations institutions. The first of these areas is around bargaining. These amendments were actually quite substantive. So they deal with bargaining disputes, the boot test or the boot, cooperative workplace bargaining stream, initiating bargaining, the formation of the National Construction Industry Forum, single enterprise bargaining stream, enterprise agreement approval requirements, sunsetting of zombie agreements, the supported bargaining stream, and the termination of enterprise agreements after their nominal expiry date. The first of these deals with bargaining disputes. So effective 6 June or earlier, where a bargaining dispute remains unresolved, a party will be able to apply to the Commission for a declaration, and that declaration will be called an intractable bargaining declaration. In order to make the declaration, the Commission must be satisfied that the dispute has been dealt with under Section 240 of the Act, so that relates to conciliation, and that the applicant applying for the declaration actually participated in that process. Bargaining has occurred for at least 9 months, or 9 months has lapsed since the nominal expiry of the previous agreement. There is no reasonable prospects of an agreement being reached if the declaration isn't made, and it is reasonable in all of the circumstances to make the declaration, taking into account the views of the appropriate representatives. If a declaration is made, then the Commission will have the power to arbitrate the dispute and issue a determination as it relates to those matters that are still in dispute. However, it is likely prior to arbitration that the Commission will order the parties for further periods of negotiations. Historically, it has been quite a high bar for parties in order to access arbitration with regards to bargaining disputes. And whilst these changes do provide a little bit more access, the bar does still remain quite high. This particular avenue will also not apply to greenfields agreements or bargaining in the cooperative workplaces bargaining stream, that we'll get to in a moment. For those that are unaware or would like to know what a greenfields agreement is, it's an enterprise agreement relating to a genuine new enterprise. So for example, a new business, activity, project, or undertaking, which is made at a time when the employer or group of employers have not yet employed any of the persons that would be necessarily covered by the enterprise agreement. So that's what a greenfields agreement is. The next amendment was made in regards to the Better Off Overall test, or the BOOT. So these changes come into effect on the 6th of June or earlier. They apply to all enterprise agreements made, so that is voted up by employees on or after this date, so on or after 6 June. The changes are designed to simplify the BOOT, which has historically been quite complex and really has resulted in enterprise agreements being approved with undertakings from employers, and has also extended out approval timeframes. Essentially, the BOOT is designed to ensure each employee that's to be covered by the enterprise agreement is better off overall when compared to their relevant award. So these amendments do seek to clarify that the BOOT is a global assessment rather than a line-by-line comparison, which has actually occurred in the past. It does require the Commission to consider patterns or kinds of work or types of employment that are reasonably foreseeable in the enterprise that and/or agreement that it relates, so not to take into account things that would not reasonably occur within that particular workplace. The amendments also require the Commission to actually consider the views of the parties and give primary consideration to any common view shared by either the employee organisations, so that, for example, is unions, and the employer. But they are still required to make their own independent assessment. It will also enable the Commission to amend an agreement where it's necessary to address issues around the BOOT. And it will also enable, or the changes also enable, a reassessment against the BOOT if circumstances weren't properly considered at the time it was approved, and also allow for the Commission to make those amendments, and in some cases make them retrospectively. Excuse me. The next amendment that is made is about cooperative workplace bargaining stream. So this comes into effect on the 6th of June this year or earlier, and it is essentially designed to replace or rename the existing multi-employer bargaining stream. This particular stream for bargaining is voluntary, and it doesn't allow an employer to join with other employers to make an agreement. At least some of the employees involved in bargaining in this area of the stream must be represented by a registered employee organisation, so for example a union, and the agreement must still pass the boot and be approved by a majority vote of the employees. This particular stream also allows employers to opt in to any existing agreement as long as a majority support of its employees is held. Under this stream, protected industrial action is not available, and conciliation or arbitration by the Commission can only occur with the consent of all the parties. Employers and employees within the building and construction industry or undertaking building and construction work are also excluded from this stream. And you'll note as we go through the session today that that's actually a common theme with a number of these streams. This particular stream for bargaining is designed for small businesses, but it is open to businesses of any size to participate. The next changes or amendments that were made to the Act relate to the initiation or commencement of bargaining for single enterprise agreement. So this actually became effective on 7 December, and it removes the requirement for an employee bargaining representative, so for example a union, to obtain a majority support determination from the Commission to initiate bargaining. Essentially, a single enterprise agreement bargaining process is where it is essentially one employer and their own employees. There's no one else really involved. The changes now allow a bargaining representative, for example a union, to give an employer a written request to bargain if the proposed agreement will replace an earlier single enterprise agreement that's past its nominal expiry date. No more than 5 years has passed since that date has expired, and the proposed agreement will cover the same or substantially the same group of employees as the early agreement. Previously, in order to obtain a majority determination to get an employer to the bargaining table, a union would be required to show that the majority of employees covered by the agreement actually wanted to bargain, which often required secret ballots, survey written statements, or petitions. So essentially these amendments are designed to simplify the process to initiate bargaining for single enterprise agreements. If all of those requirements are met, then an employer is required to bargain with the employees for a new enterprise agreement in good faith. This particular facility doesn't apply to bargaining for greenfields agreements, or if a single interest employer authorisation already applies. So we'll get to single interest employer authorisation in a moment, but it is essentially an authorisation issued by the Commission that entitles multiple employers to use one enterprise agreement. The next amendment under the Act was in relation to the establishment of the National Construction Industry Forum. So this becomes effective on 1 July. It establishes a statutory advisory body to provide advice to the government on issues specific to the building and construction industry. So that may include workplace relations, safety, gender equality, etc. It's to be chaired by the Minister for Employment and Workplace Relations, as well as other members will include ministers from a variety of portfolios. Other members are appointed as required, but it does require that there be an equal number of employee and employer representatives from within the industry. And excuse me, the forum will be required to publish a communication within 14 working days of any meeting that's actually held. The establishment of this particular forum, and we'll get to this a little bit later, but following the abolishment of the Construction Commission, this forum is essentially designed to sort of take over some of those issues that the Commission dealt with, not all, and still provide a statutory advisory body to the government around the building and construction industry. The next area of amendments that the Act occurred was the single interest bargaining stream. So effective the 6th of June, these amendments removes the requirement for ministerial declaration for some employers to participate in a single interest bargaining, whereby they now only need to apply for a single interest employer authorisation. Previously, in order for multiple employers to participate in this particular stream, they had to be franchisees, part of a joint venture, related body corporates, unless a declaration by the minister was made. The changes do, though, allow the Commission to make this authorisation to cover an employer with or without its consent. And this particular amendment and change was quite a contentious one when the Act was being, or the amendments were being debated in Parliament. So essentially, the changes allow the Commission to make the authorisation if the various employers agree to bargain, or a majority of employees who will be covered want to bargain. So that is even if their employer doesn't consent. Employers do, however, have to have a clearly identifiable common interest. So for example, geographical location, nature of enterprise, or be part of a common regulatory regime or scheme. The group of employees being covered by the authorisation was fairly chosen. So for example, geography, operational or organisational considerations. In regards to this and the activities of a common interest, they do need to be reasonably comparable. So for example, seeking to include an employer based in Townsville, Queensland, with an employer based in the Pilbara, WA, may raise questions of reasonable comparability. In addition to that, at least some of the employees to be covered are to be represented by an employee organisation, so a union. Both sides have actually had an opportunity to express their views, and it's not contrary to public interest to do so. It is important, though, that an employer cannot be compelled or required to bargain if they are already covered by a current enterprise agreement, or the employer has already agreed in writing to bargain for a replacement single enterprise agreement, or the employer is a small business. There is a difference here in regards to a small business. So in this particular aspect, a small business is an employer with fewer than 20 employees, in comparison to other areas of the Fair Work Act where a small business employer is one that has fewer than 15 employees. So it's a difference that is important to note. The Commission also has the discretion to refuse or add an employer if good faith bargaining is actually already occurring. There's a history of effective bargaining between the parties, and less than 9 months has lapsed since the nominal expiry date of the previous agreement. Again, those within the building and construction industries are precluded. Protected industrial action does remain available under this particular stream, but there are some additional measures, and they include mandatory conciliation and a requirement for at least 120 hours of notice for the action. Stream participants are also have access to the intractable bargaining process, which we talked about a little earlier when dealing with disputes, and that is they have access or the ability to seek access to conciliation and arbitration by the Commission. The next amendment that's made is in regards to the approval requirements for an enterprise agreement. So this change will become effective on 6 June this year or earlier, and it will apply to any proposed agreement for which the notification time occurs before commencement. So a notification time or the notification time is generally the date an employer starts or agrees to start bargaining. These amendments are designed to simplify the EA approval process and does remove the very strict requirement to provide employees with access to the enterprise agreement during a 7-day access period prior to voting, and in some circumstances, the requirement to issue a notice of employee rep rights and wait 21 days before a request for voting. Instead, the amendments will replace with a flexible single broad requirement that the enterprise agreement has been genuinely agreed by the employees to be covered by the enterprise agreement. In order for that to occur, the Commission must be satisfied that the employees had an informed and genuine understanding of the agreement being approved. And given that a genuine agreement is quite a broad statement, the Commission will also be required to publish a statement of principles to provide guidance on how an employer can meet that requirement. The Commission will also, however, retain the power to disregard minor procedural or technical errors, if they are satisfied that employees are not likely to be disadvantaged by the error. For multi-enterprise agreements, so that is those under the new cooperative workplace agreements, before requesting employees to vote on approval of an EA, the employer must obtain written agreement to the request to vote from each bargaining representative for the agreement, for example, a union. The Commission, however, does retain and will have the power to make a voting request order if that written agreement is unreasonably withheld. The next amendment, and this is quite a substantive one for those that do have this type of agreement, is around zombie agreements. So effective the 7th of December, zombie agreements or zombies will automatically sunset at 5 p.m. on 6 December 2023. That is, on 7 December 23, they will no longer exist. Zombie agreements are enterprise agreements that were created prior to the commencement of the Fair Work Act, so prior to 1 January 2010. And they were agreements that did not generally have to be as favourable as the award, as long as the base rate of pay was no less than the current award rate. What this means, though, is that employers that have these agreements are required to notify their affected employees by the 6th of June. And they need to notify them that they are covered by this type of agreement and that the agreement will terminate or automatically terminate unless an application to extend is made to the Fair Work Commission. After a zombie has ceased to operate, so in this case without an extension as of 5 p.m. 6 December, so 7 December, only minimum pay and conditions will revert to the award unless a new enterprise agreement is negotiated. Now, these types of agreements can be extended for periods of up to 4 years at a time upon application to the Commission. Extensions can be granted by the Commission if it's appropriate, and so that may be if employees are actually better off under the agreement in comparison to their award, or if bargaining to replace the enterprise agreement is already occurring and has commenced. These types of agreements can be extended more than once, but the reasons for the extensions or refusal must be published. So this particular amendment, for those that are on or have these older types of agreements, and there are still some floating around, it is quite a significant one and one that should be acted upon. The next stream is, or the next amendment is around the supported bargaining stream. So this change becomes effective on 6 June. It is essentially sees the existing low-paid bargaining stream renamed to the supported bargaining stream. The previous low-paid bargaining stream was actually quite difficult to access, and since its creation, there were only 4 applications made to the Commission, with only 1 being granted, so hence the amendments. The stream permits bargaining across multiple employers in low-paid industries. So, for example, aged care, disability care, and early childhood. And the changes allow a bargaining representative or employee organisation, for example, union, to apply to the Commission for a supported bargaining authorisation. That authorisation would require multiple employers to bargain together for a supported bargaining agreement. The Commission will issue that authorisation if it's satisfied, it's appropriate, however, taking into account paying conditions in the industry, whether the employers have a clearly identifiable common interest. So, for example, geographical location, nature of the enterprise, terms and conditions of employment in those enterprises, and whether they are substantially funded either directly or indirectly by government funding, and that can be either via federal, state or territory funding. It also requires the Commission to take into account whether the likely number of bargaining representatives is manageable, and any other matter the Commission considers appropriate. In addition to these, the Commission also needs to take into account that at least some of the employees are represented by a registered employee organisation. So, for example, a union. Alternately, the Commission is required to make this authorisation if an application is made and the employees specified are employees in an industry, occupational sector declared by the Minister. If the employees are within an industry, occupational sector declared by the Minister, then the Commission is not required to take into account any of those other factors that I mentioned earlier, so paying conditions, identifiable common interest, but rather they must make the order or authorisation. Bargaining orders are available, and applications to deal with bargaining disputes can be made by a single bargaining representative as part of this particular stream. If an agreement is unable to be reached, then the Commission can make a binding determination under the new intractable bargaining declaration process. So that is access to conciliation and arbitration. Industrial action is permitted and protected with the mandatory requirements of conciliation and at least 120 hours notice. And again, those in the building and construction industry or undertaking building and construction work are again precluded from bargaining in this stream. Termination of enterprise agreements after their nominal expiry. So as it currently stands at the moment, a number of agreements tend to sit within the system after their nominal expiry. However, these amendments, which became effective on 7 December, requires the Commission to terminate an enterprise agreement that has passed its nominal expiry on application if its continued operation would be unfair to employees, that is. The agreement doesn't or is not likely to cover any employees, or its continued operation would pose a significant threat to the viability, of an employer's business. These amendments replace the previous public interest test for terminating an agreement after it had passed its nominal expiry. However, terminations approved due to threat to the viability of an employer's business must also be likely to reduce potential job losses. If a termination is undertaken based on that basis, the employer must also give the Commission a guarantee of termination entitlements in relation to redundancy, insolvency, or bankruptcy under the current enterprise agreement. And any application for termination must be heard by the full bench of the Commission if the agreement still covers employees and the application for termination is opposed. So it's not, whilst there has been some amendments made, I wouldn't suggest that it's going to be particularly easy to be able to terminate a enterprise agreement after its nominal expiry date. The Commission must, of course, also consider whether bargaining for a new agreement is occurring, and if by termination it would adversely affect the employee's bargaining position. So as I said, whilst these amendments are designed to potentially make it a little bit easier, I don't suspect that it's going to be too easy. So the next area of the amendments that were made in regards to workplace relations institutions. So this is the abolition of the Australian Building and Construction Commission. We briefly touched on this when talking about the Construction Forum earlier, and the abolition of the Registered Organisation Commission. In regards to the Australian Building and Construction Commission, this came into effect no later than 6 February this year, and essentially the Commission is abolished and the Code for Tendering and Performance has been repealed. This amendment essentially transferred power to the Fair Work Ombudsman to regulate compliance and enforcement of the Fair Work Act within the building and construction industry. The original Building and Construction Industry Act still remains in play. However, any reference to the Commission has been removed, and its objectives have been amended to reflect that it is simply there to promote work health and safety within the building construction industry and building work. The next amendment was the abolishment of the Registered Organisation Commission. This takes effect on 6 June this year, if earlier. And essentially the Commission is abolished and all powers transferred to the General Manager of the Fair Work Commission. All previous reporting requirements, powers for inquiry, investigation or proceedings remain in play, but they're simply transferred to the General Manager of the Commission. However, the amendment does also introduce some modernised enforcement options, and they include infringement notices and enforceable undertakings. So where to from here? We have gone through a fair bit in regards to amendments to bargaining schemes, and for some employers that don't currently participate in any form of enterprise bargaining, it may not seem particularly relevant. However, all employers and employees for that matter really do need to be aware of these changes, particularly in relation to the single interest enterprise agreements, as well as those operating in those low paid industries. So that is aged care, etc. And the ability of the Fair Work Commission to include employers with or without consent. And so if you are seeking or looking to undertake some bargaining, please make sure that you're seeking the relevant advice, whether it be reaching out to us or someone else. And likewise, if you get wind of, or you're informed of after the commencement date of these changes, your inclusion in one of the multi-employer bargaining streams, then it really is important that you seek advice as soon as possible. As I mentioned a little earlier, in regards to zombie agreements, if you currently operate under this type of agreement, so that is an enterprise agreement that was in place prior to January 2010, you need to ensure that you are complying with your notice requirements on the 6th of June. And you seek some advice in regards to this, particularly if you are wanting to seek an extension for the agreement, or you receive notice that your employees are seeking such an extension. I will also note those brief actions that we talked about last week in regards to those amendments around the use of fixed term contracts. For those that have pay secrecy clauses in their employment contracts, and of course, making sure that you're aware of all of those other amendments that we chatted about last week. So that's kind of it for our part 2 and the second tranche of amendments. And I noticed that I've again managed to get this done in pretty good time. So I always say that a good webinar is a quick webinar, but if anyone has any questions, please make sure that you're popping those questions in the notice below and in the question section.